Yeah, thank you so much for joining this session on copyright for specifically for CAHSS. And thank you to the center directors, to Christine Mallinson, Denise Maringalo, and Lynn Casaban for organizing this and enthusiastically jumping on board about for this session, and specifically to Amy Barnes of CS3, who helped to publicize it for us. I of course want to thank Wendy Martin, who's the director of the Office of Technology Development, which is under the umbrella of the Office of the Vice President of Research, and Krishna Gohel, who works in the Office of Technology Development with Wendy, who's the intellectual property coordinator. Actually, I heard Wendy speak about intellectual property and field some questions on copyright some time ago, which I thought were fascinating. And I thought that perhaps, faculty and grads in CAHSS would be interested in hearing about this, maybe asking some questions, and also specifically just knowing that there's someone with this expertise in our university that you can go to in future times, even if it's not right now. So, and as you're aware, the Office of Research Protection and Compliance, which is also under the division of the Office of the Vice President of Research, requests that all graduate students at UMBC complete this a course on, it's called RCR, the Responsible Conduct of Research. And it's to alert our graduates about our graduate students about the ethics and procedures for conducting research in their disciplines. And copyright is oftentimes one of the issues, at least in the arts, the right of artists over their creative works, and it can become a fraught question. And likewise in collaborative works, the rights of each individual over the work, or in the case of the university, when the university is supporting the research, the right of the author, artist, and the institution are questions that come up. And so without further ado, I would like to turn this over to Wendy and Krishna. Thank you so much for being here.
Okay. Krishna, can you share the screen? Will it work in presentation view? There we go. Okay. So thank you, Perminna, for the introduction. And again, we're from the Office of Technology Development. And just a little note about Krishna. She's new. She's actually a UMBC grad and recently graduated from the UMB Law School, and is a patent agent waiting on her state bar results. So welcome back to UMBC to Krishna. Okay, so next slide. So our office is responsible for the intellectual property portfolio of the university, and protecting the intellectual property and commercializing it. And that includes evaluating any inventions or for patentability and market potential, and also copyrightable things as well. We utilize outside patent counsel to file patent applications and copyright and some trademark registrations. We review, negotiate things like material transfer agreements and non-disclosure agreements related to UMBC technologies. And we also negotiate licenses. So if a company approaches us and wants to commercialize one of the things that we have, we work with them and license the technology to them so they can commercialize it. And we monitor, the license. They have milestones they have to meet, and then revenue that would be distributed to us on royalties and payments and things like that. And we also assist entrepreneurial faculty in new company formation. And just generally, our role is transferring the technology that's developed at UMBC out to society to benefit the general public. Okay, next slide. And just briefly, what is intellectual property? Well, it's a creation of the mind, really, the intangible asset developed by human creativity, but it's protected by legal means. And we're going to talk a little bit about those, concentrating on copyrights. But patents, trademarks, copyrights, and trade secrets is the umbrella of things. And why is this important? Well, it's core to the mission of the university to create and disseminate knowledge and share it with the public. And that's important because protecting that intellectual property actually allows us to do that. So companies come in and they can take the technology. And if they didn't have that protection, if they couldn't exclude others from getting into it, they wouldn't invest in commercializing technology, because a lot of investment goes into commercializing something before it actually is bought by a consumer. And so that investment comes with the company investing in it. And so some of the protection that's afforded under U.S. law, just trying to tell you what they cover. So patents cover inventions, right? Or trade secrets, and we're not going to get into that piece of it. The trade secrets would be an example of that would be like the formula for Coca-Cola, for example. Literary, artistic works, music, so that kind of thing. Sculptures, videos, protected by copyright. And then things like symbols and names and words and images that are associated with a product, that's sold back and forth in commerce, that's protected by a trademark. And so with that, I think Krishna is next to talk a little bit about all those types of things.
Yeah, so can you guys hear me? You can hear me? So we're going to go into the different kinds of intellectual property just a little bit. Patents basically it's a property grant by the federal government to an inventor or an applicant for an invention that's useful, new, and not obvious. It covers a machine, process, article of manufacture, or composition of matter. Usually the term is about 20 years, and I say about because it differs depending on which patent application it is, but we're not going to go into those. And I think the most important thing to note is that a patent actually gives you the right to exclude. So it's a negative right, which means that you can exclude others from making it, but it does not necessarily give you the right to actually make you sell that invention. And then next we have trademarks. So trademarks is really like the fun, colorful IP. I guess it's the one you see in everyday life, right? If you've seen all of these logos before, all these slogans, if I say, let's do it, what company that's referring to. So the requirements are use in commerce, which means that the word, symbol, slogan, or logo must be used in selling something in commerce. And there are two ways that you can give notice, really. So notice means you can put TM or SM next to a slogan, word, symbol, meaning trademark or service mark, even if you're not registered. That just means you're protected by common law. It gives notice to others. Hey, I have a trademark on this, or I am claiming to have a trademark in this. But if you register it with the USPTO, you can use that circle R that you can see on the slides. And that just gives you the right to sue others for using it in commerce. This is what makes trademarks a little bit special, a little bit more interesting, is that the term is unlimited. That's how they differ from patents and copyrights, is that you have a trademark in that as long as it's being used in commerce. And the main purpose is just to avoid confusion in the marketplace. Common example being if you just walk into a grocery store, all you see is laundry detergent. You don't know one is Tide, one is Bounty? No, that's paper towel rolls. But the different kinds of detergents, you don't know which one is which unless you see the color scheme, unless you see the logo. So really the main purpose of trademarks is to avoid that confusion. And then last but not least, we have copyrights. So this is a little funny comic. If you guys want to just take a couple minutes to look at that. That was funny. So basically, the requirements for copyright are none. And we say that because you do not have to register anything in order to have a copyright in something. Once you have created that original work and it's in a fixed, tangible form of expression, you have a copyright in that tangible thing. But if you want to sue somebody for infringing on your copyright, then you have to have it registered with the Copyright Office. So that's why we say none, but recommendation is that notice. Something that differs or something that sets copyrights apart from the trademarks is that you can use the Circle C even if you have not registered your copyright. So you can see right there, I put a little example, 2010 University of Maryland, Baltimore County. You've probably seen that in textbooks or handouts or things. That's just the copyright notice that UMBC uses. So the term for this is life plus 70 years, but if it is an anonymous work or work made for hire, then it's 95 years from publication or 120 years from creation. So here we just have some current events, some fun things if anyone is interested in what's happening in the news and copyrights today. So these are two different cases that are actually going on in the federal circuit right now. One of them is between a German citizen and Apple for illegally streaming the Austin Powers movie on Apple TV. So the German citizen had gotten this copyright from a defunct production, and he sued Apple saying that they had both infringed on his copyright and engaged in contributory infringement, which just means that Apple encouraged or induced its customers, its consumers, to stream the Austin Powers movie. Long story short, the federal circuit said, yes, Apple, you are liable for copyright infringement. This German citizen owns the copyright. You did not get his permission. You did not cite him when streaming this on Apple TV. Therefore, Apple, you are liable. And then kind of on the other hand, Disney versus Marvel. So everybody knows Stan Lee created the comic books, the Marvel comics, and all of these different characters in the Marvel universe. Now, Pixar long ago had bought those rights from Stan Lee. And then we know Disney bought Pixar. Disney bought a whole bunch of stuff, but one of those things was Pixar. And in that, they got the rights to the copyrights for all of these different Marvel characters. So basically what Disney did was they brought something called a declaratory judgment, which is just kind of covering their own butt, saying, hey, court, we are sort of forcing Stan Lee's estate to sue us and for you to make a judgment on are we infringing on their copyright, yes or no. So they brought this case. The court said, no, you're not infringing on their copyright. You have all rights to these Marvel characters for you to make further movies. So that's something interesting, kind of one where the big dog wins, one where the big dog doesn't. So those are two things that are kind of happening right now in copyrights. Okay, so to kind of jump right into, everybody's heard fair use, right? You know, you've heard a little bit about fair use, you kind of know what it is, but the fair use defense is exactly what it sounds like. It's a defense when you when somebody says you have sued or you have infringed on my copyright, this is a defense that you, the infringer, can use in order to say, no, I actually did not infringe because this was a fair use of your work. So we want to make very clear though, just up front, yes, you can still be sued and you may still be sued for infringing on someone's copyright. But the fair use defense says you have a defense to it though. So the fair use defense does not mean you won't be sued. It just means when you do get sued, if you do get sued, you have a defense to say, no, but this was a fair use of mine. So the Copyright Act, 17 U.S.C. 107, it just says that the fair use of copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. And the factors that the court looks at are the 4 factors listed here. I won't read them out, but you can go ahead and read them yourselves. But I just wanted to make sure that I note that all of the factors are weighed together. It's a subjective determination, so it's very fact-based. Just because something went one way one time does not necessarily mean that it will go that way another time. So it's very fact-based, and it's a subjective determination by the court. But again, you can be sued for copyright infringement. This just means that you have a defense, and you have a very good defense if it's for one of these uses. So yeah, here are just some examples. The main point being, though, before I go into the examples, is always attribute or ask for permission. Because we're a university, a lot of times people will give you permission. They love their work to be used in teaching or for scholarly works or things. So most of the time, if you ask for permission, they will give it to you just because we are a university. And we just want to say err on the side of caution. So if you don't ask for permission, at least attribute to the work. But here are some examples of fair use. So parody or satire. There was a case a long time ago, I believe it was in the 1990s, where there's a song called Pretty Woman. That was a little before my time. But this song basically was used in a live action where the actors made a song based off of the tune of Pretty Woman, but it was like Hairy Woman. It was like a parody satire on the whole Pretty Woman song. Now, the court said, no, that's a fair use. That's just satire. That's parody. They're allowed to do that. News reporting is another example. Criticism or comment on a piece. That's another example. Twilight Fan Fiction. So I'm sure a lot of you guys have heard of a book series, where it was a fan fiction of Twilight. The court said that's absolutely okay because that book, the author was fantasizing about Edward Cullen, and it had nothing actually to do with the plot of Twilight, the characters in Twilight. It was just a mere rendition. It was a fan fiction of the Twilight series. So that was absolutely okay. And if you copy an image, but then you edit on top of it, you've transformed that image. And so therefore, that's another example of a fair use. Now, here are some examples of not fair use. Copying or photocopying. That's not fair use. Catcher in the Rye. So everybody has read the book, or I shouldn't say everybody. A lot of you have heard of the book, The Catcher in the Rye. I know I had to read it when I was in school. An author, what he did was he wrote a book about the main character in The Catcher in the Rye at the age of 76. Basically what his world would look like when he grew older. The court said that is not satire, that is not parody, that's basically a sequel to the book, and that's copyright infringement. So something like that is not okay. And then, of course, if you damage the value of a copyrighted work, that's also not okay, and that's infringement. You can't damage the value of this. It's like a priceless piece of art. If you've damaged the value to it, you've infringed. And now I'm going to hand it off to Wendy. She's going to go a little bit more into the different laws in copyright and resources for all of you.
Okay. First, this is the Digital Millennium Copyright, or DMCA. Maybe you've had your life turned upside down by a DMC act on your website or something, but it makes this act, and it's always changing. We're not going to go very in depth into this. It's always updated, but basically it was to address infringement as it relates to things in the digital world, and it makes it a criminal act to produce or disseminate devices or services and technologies that makes it possible to evade controlled access measure to copyright works. And so I just wanted to bring that to the attention, because it is something that affects copyright and people's use of it, because the World Wide Web is worldwide. Next slide. Creative Commons is a type of one of the open source type licenses, and there are various licenses that we can use to share things and freely. I don't mean free in the sense that it's $0. I mean just free is more freedom to share them. It's a nonprofit organization that provides these licenses based on what you want as a creator, and it helps you give permission. I mean, you own as the creator, you own it, but it gives permission to other people to use that work according to how you want it to be used. Next. And so that's sort of based on this copyleft. It's a play on copyright, actually, copyleft principle. So it gives the users freedom, and if you redistribute things like software, if you make changes to it, you may have to pay. You can pass that along, but you have to have that ability if you use the original software. So another example is I'm making, modifying something, extending it. That version also has to be able to be free freedom to use, not just free there. Next slide. This is another type of open source thing. The general public licenses. It was designed by this group called Free Software. And again, this is another type of open source thing where if you want to share source code, that type of thing, there's a community of people that use this as well. I think it started actually at MIT, a certain version of it. But anyway, it's another example of ways that people can share things freely. Okay, next slide. Works made for hire. It's part of the Copyright Act, and it basically says if an employee is within the scope of their employment, if they create a copyrightable thing, the employer owns it. And whoever, if it's a commissioned work also, and that could also be part of the work made for hire doctrine underneath that Copyright Act. And I kind of introduce that as a segue into kind of the next slide. Oh, okay. So before we get into the policy, if anyone has any questions, I wanted to stop here because we have gone through, and I know there may be some questions or comments in the chat, maybe. Okay, so Jill, how does sampling, say, in music or dance fall into fair use and copyright? Are you on? Can you actually ask your question? Unmute yourself and ask the question. If you have a specific example you want to ask us. I think you're not unmuted. You have to unmute yourself or somebody. Okay, there you go.
I was just saying, pardon me, I'm multitasking and having lunch too.
That's okay, no problem.
So I've been digging into this a little bit, and I actually wrote a short article on TikTok and copyright over the summer. And I guess my interest is dance. I'm in the dance department at UMBC. And I guess I was curious to know how much dance or how much music can you use before you're infringing, like what length, like any movements?
Yeah, so a general rule of thumb, particular, and again, these all have nuances to them, and so just kind of take that with a grain of salt. So individual dance moves can't really be copyrighted, but if you choreograph an entire dance, right, a sequence of moves and put them together, that can be copyrighted. Okay, so but the compilation of a bunch of people's moves, I don't really know what to tell you on whether that would be infringing something, because you'd have to look at the copyright of each of those individuals. And that's why we say, to err on the side of caution, which is, ask permission or, attribute. Definitely in this situation, I would recommend asking permission of that. But again, copyright, you can't get a copyright just on one dance move. It has to be a choreographed sequence of dance moves. Is that what you had asked? Okay, somebody else is asking something.
That was in general, but I guess I'm and maybe that's where I need to do some more research as to like how much, like if I know one move is not copyrightable, like you can't copyright the moonwalk, but
right.
Like how many movements in a row all are enough, like that. I think that's one of the big questions coming up with all these TikTok sequences too. And
yep. Yeah. And again, we don't know that we have case law really. So, my recommendation would be consult someone who deals with this, right? Which is not us. We're not the folks who deal with this. We're really just kind of relaying to you, the general things that are out there. And these are all great questions. How much does it constitute? And then you could ask the same thing for a book, for example. So, Krishna just said basically totally copying a book. Well, you can't do that. But, if I say, oh, I only copied, 10 pages. Well, how long was the book? Well, you've copied way too much of that work, right? And so it's fact-based, and it can be up to a court really to decide if you've taken too much, right, of the original work. And you asked about music sampling, same thing, right? It had, decided by a court if it's too much of the original work that you're using. So, I'd have to tell you that, you'd have to consult, so some legal experts who deal with this and understand the case law a little bit better than we do. We just kind of giving you information like, hey, you can't go off and, copy an entire, choreographed dance, which most people understand. But how much of it you can use and put together, that really is a lot of case law that we're just not familiar with. Okay, so
I have a question, please.
is that, I'm sorry, who's speaking? Kathy?
Gloria,
Oh, okay, I'm sorry. Hello?
do you hear me?
Yes.
Okay. I had a personal experience. I wrote a dissertation in 1995 in an African country, West African country. It happens that a few years after, part of that work was reproduced in subsequent dissertations written by other scholars. And my attention was drawn to it. I was advised to register the dissertation here in the US. But my question is, I did register the dissertation here in the US, but I don't know what else to do. So my question is, can you, because I think it was is it Krishna that mentioned something about 95 years, 120 years, or something like that. So my question is, can one backdate copyright infringement? Since the work was produced in 1995 and was copied, say 5 years after, and was registered 3 years after, I found out that it had been copied.
Right.
Can I sue the person who copied the work even?
So I understand the question. I kind of understand where you're going with that.
Okay.
Okay, now there's a sequence of events that should take place, and you brought up a good question, which is, hey, I didn't register a copyright on my dissertation or get a copyright on my dissertation right away, right? So in other words, when I published it, yeah, you're afforded the fact that yes, it is copyrightable, it's copyrighted, people shouldn't take it, right? In its entirety. Obviously, if they're taking bits and pieces out of it, they may think they're actually in the fair use safe harbor. I don't know. But your good question is good in that it said, you did not register that right away. You register after you found out that people were taking either bits and pieces or large portions, I don't know, of it. And then what can you do in terms of suing people to get them to stop using it? Now, it's going to cost you money to sue the person, right? You'd have to register where they're infringing, which you're saying isn't the United States. Is that what you're saying? It was some other place? So you have a registered copyright in the United States. That doesn't mean that you have it worldwide. You'd have to get it in the other countries. Okay, that's one part of your question. So my answer really is you'd have to, it's too many moving parts to your question. Right. So if you'd have to consult an attorney, why would you do it? It's expensive to do. What are you losing by them taking your work? Are they not attributing it to you? Maybe you could contact them and tell them, hey, you haven't attributed this work, and it's mine. You haven't attributed to me. I want you to reference it in a certain way. You could, I'm not saying that there's alternatives to suing people, right? What is it you want to accomplish? And has it taken away from you financially, monetarily? In other words, are you trying to sell that and they're offering it for free in something of their, and I'm playing the devil's advocate here because you have to ask yourselves those questions. It's not just, oh, they're using something that's mine and they should attribute it to me. why are you suing them? Why don't you just contact them and say, you're not saying this is from me, and it was, and I just want you to attribute it to me. There may be that alternative as an option. That's just all I'm saying. So, and then your question about the sequence of events, yes, there is something to the sequence of events and how you may now, since you have registered, but you may not be able to go back and sue them for infringement if it was before you registered it. There may be problems with that. Copyright law, again, you have to consult, an intellectual property attorney about that. But I'm just kind of giving you some alternative thoughts on something you could do that's free. Actually, you could just contact them and say, hey, you didn't reference me. That's something you could do. Okay, I have another couple questions here. I think Kathy Odell has a question.
Hi, Wendy. Yes, this is Kathy. My question relates to the visual arts and specifically to an item that we have started to produce in our graduate program, our Intermediate in Digital Arts program. Starting several years ago, we started working with our graphic designers in our department to turn the MFA written thesis into a book, a self-published book. Okay, so when the grad students write their 5,000 word written thesis, they often incorporate images of work done by other artists that have been touchstones for them, influences. And so when it's just the thesis that gets deposited with the graduate school, everything's protected under fair use because it's, ProQuest falls under an educational entity, so it's fair use. But when we incorporate those images into our design of the thesis as a book and then upload to the self-publishing platform called Blurb, we have assumed that the students do need to get permission for those images. Now, some of those images, the copyright is held by the museums that have these artworks in their collection. Now, over the last couple of years, a lot of museums have added more and more work to open access, but still not all. And sometimes the price tag on getting permission, copyright permission, is really steep. Nothing our graduate students we would expect our alums to pay, but we can't pay it either. So are we worrying too much? That's always been my question. Are we worrying too much? I mean, we've always said to the graduate students, hey, this is a great opportunity. If they're living artists, it's a great opportunity to get in touch with the artist because there's professional advantage to you that they know that you're following their work. And sometimes the artists have said, living artists have said, sure, use the image for free, or just send me $25 or whatever. But, if it's a museum work, it could be hundreds of dollars.
Right. Yeah. So your question, as I understand it, is, are you worrying too much? Is that what your question is?
Yes. Could we just not, could we tell the graduate students, don't worry, we're just going to
I would not recommend telling people not to worry if there is a copyrighted image that a museum has control over, and that if they see, so err on the side of caution. If you don't think you have the free use of it, and if you're saying this is a published book and it's kind of beyond, just the thesis that sits in our library, I would say you would have to think about getting permission to use it or not using it.
Okay. And what if it were a detail from a work? What if the student has written about, the shell on which Botticelli's Venus is positioned, and they just do a detail of the shell? Then we're okay, right? We don't need permission then because it's a detail.
Are you talking about writing something about a painting?
Yes, exactly.
Oh, okay, so that's comment. That's comment on a painting, and that's covered by fair use, right? Criticism, comment, news reporting. Right.
All right. So if the student is talking about a work of art, let me put the detail thing aside. They're talking about how Botticelli's Venus actually influence their work, and this is how,
Mhm.
then that's criticism or comment?
Yeah, that's not the image itself, which is what's copyrighted.
Huh.
Let me give you an example from the book world, okay? The Harry Potter books, okay? Copyright coverage on a book about a boy, a book about a boy wizard who lives at Hogwarts, who has friends named Ron and Hermione, and that world, okay? She can't keep somebody else from writing a book about a boy wizard, okay? She can't do that. What she has it on something specific, right? So the something specific in a painting, is a painting or a picture of painting, that image. If you write something about it, you're commenting on it. That's a criticism, comment, or news reporting, or so forth, and you're not, you know, then using the image without permission.
Oh, that's very interesting. Okay, so we shouldn't worry then, because they're not just publishing. It's not as if the student would be publishing an image and not for just to publish it. They're publishing it because in their writing, because they are referring to it.
Oh, okay. So if you're publishing the image and the criticism, I
Yeah.
would still err on the side of getting permission to publish the image.
We do.
Yeah, I would still err on the side of caution. And obviously, you can always consult intellectual property attorneys on what's been decided and what your particular facts are. You always want to err on the side of that caution.
Okay.
You always want to err on the side of that.
All right. Thank you so much, Wendy.
Okay, so I have Sandra Abbott.
I wanted to speak about Kathy's question specifically.
Okay.
So at the Center for Art, Design, and Visual Culture where I make applications for image licensing for our very active publication program frequently. And so what students might not realize are there different entities from whom they need to request copyright clearance. It's not just the museum, or so it could be if it's a deceased artist, they may need to go to the Artist Rights Society, and then they also have to go to Art Resource, which manages a lot of museums or collections, and then they have to get the level of clearance for the photography, because the photographer who took that, or the institution who took that picture, they are the ones that, if they're getting the image from, they're online, or, getting high res for publication from them directly, that's usually the clearinghouse, because larger institutions don't really do their own licensing directly anymore. They outsource to Art Resource, is the name of the organization that handles most of the major ones. Now, what we have done, because those fees can get expensive, is we go directly to the curator and try to make a deal. We play Let's Make a Deal. And we contact, for example, when Peggy did A Designed Life, she had something like, I want to say 80 images, and we and we had several with the Smithsonian, with the Design Museum, the Cooper Hewitt there. So we contacted Susan Brown, who is the curator there, and talked to her, because you will get nowhere going through Art Resource for asking them to make a deal with you, because they have a vested interest in getting their cut for handling that administration of those licensing. So you have to go behind Art Resource, and you have to go directly to the curator who is looking out for that collection, and you make a deal with them, and then you get the emails, and you go back to Art Resource, and then you get your cut. You get your, either they'll waive it or they'll cut it significantly. And then where we really got tripped up is when we tried to go for estate images.
Oh,
Estate
goodness, yes.
images are a nightmare. You have to go through Art Resource, and that's why we ended up taking out Saul Steinberg images, and Alexander Calder. We had to drop Alexander Calder from the show because the estate fees were prohibitively expensive. And you
Right,
have to go
right.
through a separate source, and they don't want to work with you, and there's no way of getting to the estate usually. Sometimes you can get to the heirs of these people through channels or whatever, but if they've registered it with the Artist Rights Society, most likely you're going to have to go through them, and they are terrible to work with because they take a long time to everything just takes so much longer going through them, so they need the lead time, and I know students often don't have that lead time. And so
Yeah, right, right,
those
right,
are a
exactly.
concern. And I would imagine that if you have any students who, want to know about this stuff, send them to me, and I will shoot them some resources and connections if I have any.
Oh, that's great. That is great information. Thank you very much. I appreciate that. I guess everybody here was like going, "Yay, there's somebody that knows about the and reduce fees and how to get." Okay, and so were there any other questions? I don't think so. Anybody else have any other questions before we kind of move on? Certainly free to answer them. So, Krishna, are we back? Okay, thank you. So we just wanted to mention a few economic development type initiatives that our office has. If you're interested, we've developed a express license that helps start companies. It's specifically for faculty and staff and students. The terms are very favorable, and this quick turnaround time is helpful when getting resources from around the region. Maryland Innovation Initiative Fund through TEDCO and things like that. We also have an internal fund for technologies. It's called the Technology Catalyst Fund. We do it once a year. Actually, it's going on right now. But we've had folks in, the digital arts area, music, and so forth, participate in these things, and even, starting companies around technologies. So just to kind of point you to that. At this point, we don't have anything else for you. We do have additional slides that deal with copyright issues around the intellectual property policy. And we've got another, 10 minutes or whatever, 10, 15 minutes or so, and I'm happy to go through those slides if that would be helpful to folks. Otherwise, I just say for information. I mean, just kind of, Perminda, is that something you want us to keep continuing on with that? Or because you've heard this stuff, so you know what it is.
Yeah, I mean, I thought it was very interesting, Wendy. And if people don't have any other questions, maybe we could just go ahead so you can kind of inform people, and then keep this in our, like I said, people get to know that UMBC actually has this, people working on this, which is great.
Okay, sure.
So, yeah.
I just interject something real quickly. Wendy, maybe I think the upcoming slides may be the ones that you showed at Faculty Senate.
Yeah.
Perhaps. Yes. Well, that's great, because if you could just touch on the question I had at Faculty Senate, which was had to do with the making available of the work of previous students.
Yes. Yes, that was one of the questions. Okay.
Yeah. Thank you so much.
I can do that. Okay, so let's just run through these, and I'll hit on that if when it comes up appropriately and through here. Okay, so there is a current intellectual property policy, and there is a proposed version of this, and we're doing this to be in line with what College Park, and actually the system has adopted a new one, and College Park did the heavy lifting on all of this. They went through, it was a couple of years ago, they started revising this for a number of reasons, but I'm going to touch on the copyright related things and help you hopefully understand things a little bit better. Okay. In the current policy, the things haven't really changed with the ownership, but if you think about it like this, basically traditional scholarly works is a defined term now in the revised policy, and that covers things like journal articles and all kinds of things. And what happens is, when we talked about it, there's this doctrine called work made for hire, and the employer will own, things that an employee makes within the scope of their employment. However, what we do as part of the intellectual property policies is we give those rights back to faculty. So in traditional scholarly works, we give those rights back to faculty so that you could go and you could publish or present those types of things. Okay, next slide. And here's the definition of traditional scholarly works. And so you can kind of go through and read it. And it doesn't treat any differently online or, face-to-face settings. These are, anything that you might use, your lecture notes, things like that. Choreographic works, photographic stuff. Again, we're giving those rights back to you, as a faculty member, so you can publish things. Okay. Now, UMBC owns the scholarly works when not only then would it violate a contract. In other words, the university was paid to have you develop something, and then in order to give those rights to whoever paid for that, the university needs to own it. Or whether if the work is created at the order of directive of UMBC, like for example, if you were in a committee and the committee was directed to come up with a report on something, well, the university would own that report because we directed you to do it. And if there were extraordinary UMBC resources that were used, that were decided upon and understood at the time, that this was kind of decided. Okay, next slide. Online courses, the old policy kind of treated online stuff differently from in-person, face-to-face courses, and now it's basically treated the same. It was repeated wording, and now it's just in one article, paragraph, section, I guess. Software, again, it was treated as a separate section in the old policy. Now in the proposed new policy, it's kind of in the same. And it kind of reflects U.S. government treatment of software and the U.S. regs. UMBC really needs to own those inventions. That means they're reportable. So you need to report things like software to us. Again, in order for us to comply with whatever contract we may have or grant we may have, even with the federal government, we have to be able to do that. Next slide. Commission to directed works. I think I may have talked about this. You're asked to produce a report. You're on a committee or whatever, and the universities ask you to do that. And that's directed work, administrative. Basically you're coming up with a form or something, and then compare that to traditional scholarly works where the faculty member is developing a new course or writing a journal article. Again, that's the faculty member would own that IP because we're giving those rights back in the intellectual property policy. Okay. Owning course materials, default position, the creator owns it. There may be some deviation from that, and unless the university's commissioned it, and also in the new intellectual property policy, the university is going to retain the right to use a syllabus. Basically, that's for two reasons. One of them is we need to be able to produce the syllabus when we are accredited, going through an accreditation process, and also to see what was taught in a specific class if the person leaves. So those are the reasons why we would retain at least a copy of that. Next slide. Okay, and if the faculty leaves, the university can't use their course materials because the faculty member owns the copyright to that. Student-owned copyrighted works. A faculty member cannot use, copy, and distribute student course assignments in which students own copyright unless you have written direct permission. Implied permission. In other words, there's a statement in the syllabus or something like that, and I would contact us, and we would contact the legal affairs folks to help you understand what would need to be in that statement if you don't already have it. Or use is authorized in the copyright law as fair use. In other words, the things we discussed. If you use a line or two, let's say somebody's written a report, a paper, and you want to use a line or two out of it, that may be fair use, but you can't use the entire thing. And I think this was kind of the question that was asked when we talked to Faculty Senate.
Yeah. So it wouldn't be that I'm referring very specifically to the visual arts department now, and we are going through accreditation with National Association of Schools of Art and Design. they ask us to upload and make available to them student works.
Okay.
And so the response that I got from you, Wendy, about erring on the side of safety and getting written permission from those students, just about caused a coronary in at least 3 of my colleagues, because, they say there's no way we can do that. It's impossible. Moreover, NASAD, the acronym for National Association of Schools of Art and Design, are the only people seeing this work, and it's for educational purposes. So what about
I tell you what, the best thing for me to tell you to do is just send me an email.
Okay.
And we can actually bring this to the attention of the general counsel's office if you have a question, because we may be able to ask.
Okay.
Then they may be able to have a better sense of it. But erring on the side of caution is always the best. Now, like you said, the folks who are seeing this, you need to make sure that they're not using it for something else, and so that's when you might get into trouble, right?
Right.
They're then, and here's an example of what somebody else has shown us before, and here's a bunch of artistic works, and then somebody whose artistic work it was when they were in college says, hey, that's mine. And they may be flattered. I don't know. But they may say, now somebody's using that and making money on it somehow, some way. I don't know. That's when you get yourself into trouble.
Okay. I'll send you an email, Wendy, and I'll copy our department chair and the person leading the NASAD effort and our associate chair. Thank you so much.
Yep. Okay. Like, again, there are facts around everything. And as soon as those facts changed even a little bit, well, that affects, what you can and can't do, right? Just like anything else. Okay. Next slide.
I think we have a question in the chat.
Okay.
Yes, that's me. What if we're doing a web or a WebEx class, and someone screen shares their work, and we are trying to share the class with students who couldn't make it to class, so they have access for non-syncretized. How does it cover that, and is there a problem with that? Because I thought that was the best practice to make our classes available.
Yeah, we've had a similar question when we presented this to faculty senate, and the question was around these WebEx recordings of lectures, and who owns that, right? And so I had a talk. I didn't get a written opinion from our legal affairs folks, but I did have a talk with him about that question. And essentially, we kind of came around to it's basically like the person's course materials. It's really no different than that. And what's the policy say about that? Well, the policy really says the faculty member owns the course materials, and if that includes a videotape of them giving a lecture, that includes a videotape of them giving a lecture. So it's basically the faculty member's lecture that was a question, and it's one that was captured via WebEx, but it's basically a video of them lecturing. So the verbal opinion is it's the faculty members. So your question about, if students are screen grabbing or whatever they're doing, there may be some facts around that we may need to discuss offline. If it's different than the answer to the question that I just gave.
Yes, I didn't say screen grabbing. I'm saying sharing.
Sharing.
Sharing. So, for example, you're in a classroom and a student says, "Could I just screen share to sort of illustrate what I'm talking about?" And then they put their work up on the screen, which is still recording, and then share the entire class. And now you've got your class, which is your work. It's the instructor, but now it's in there. The student work is embedded in it.
Yeah, so you have this. Yeah, you have this situation a lot, right? When you're, and this happens. That's why a lot of things aren't copyrighted, because people do grab images and things from other people's work all the time. And so, trying to enforce a copyright, somebody could say, well, wait a minute, that recording included embedded in it a PowerPoint presentation or a couple slides from a PowerPoint presentation that's mine and not yours. And so you're going to have to take that out if you ever want to use that. Let's just say that video, you're going to have to take that out because I don't want you to use it. So you're trying to use something that is mine in something embedded in something that's, you know, a larger work embedded in something that's yours. There's no different, right? There may be a situation where that does happen. So it's really challenging. And like I said, there's facts based around all this, and it's going to be challenging going forward because everything's, you know, virtual now still. And the question of whether what you can protect, can you protect all of it or only piece of it that's just originally yours, or do you need to go get permission if you're going to do that thing, that kind of thing? I think there needs to be broader discussions around all of that, and it's just too new, right? It's just too new to, you know, have a good sense of it.
And
right.
related to that, what if there was a third party that you were screening? So if a student says, "Oh, I saw something else on that reminds me of this online last, can I screen share?" And then they go and like on their screen, they're searching the web and they find a third party that is copyrighted, and all of a sudden that's your recording. Yikes.
Yeah,
right?
yeah, same thing. You know, there are too many moving parts to that, right? And how is that different than if they compiled that in a written word and went and grabbed somebody else's work and plunked it in the middle of it? You know what I mean? So, you know, if we were trying to claim copyright on something, you know, you may get a note from the people whose actual website it was and say, wait a minute, that's an image you grabbed from our website. You know, there may be fair use, right? There may be fair use. Hey, it's part of teaching and research and scholarship and all that kind of stuff, and it could be posted there, and you have a defense, right? Hey, you know, we're teaching or it's scholarship and that kind of thing, and there's your defense is it's fair use. That may very well be, but you know, there are too many moving parts to your question. So, and this comes up. This is not new with the digital age, it's just making it more complex, really. It's not new with the virtual classrooms either. There are a lot of moving parts to the question. And we just don't know the answer to them. Any more questions?
Well, I just want to say something really quick. The third party sharing thing, I think, adds a little bit more in it. But what I do know is that Maryland is a two-party consent state, right? So you, in all of the syllabi, I'm sure you have some kind of notice, especially because classes are online, that classes are going to be recorded and we need your consent to record it. And I think there could be some kind of verbiage in there with, if you share your work, if you share your screen and the professor is putting that work or putting that lecture online, just kind of like a notice that your work, if you do share your screen, may be online. You know, something along those lines. I feel like there could be some verbiage that you could put up front. Again, like Wendy said, you would have to email the office, and we could talk about it later. But I'm sure there's something you could put in there that's like, if you share your own screen and your work is being shown, you are now, you know,
by implication, you're saying it's okay for you to use it, right?
Yeah.
I guess that's, and that's probably the case, right? Just if you want to contact us offline to get a firm answer, right? You know, you can certainly do that. But the third party thing is something different, like Krishna said. They're not giving permission. You went and sought it out.
What about collaborative works when there's more than one author? Is there any particular laws that govern that?
There's just more than one author and possibly more than one owner. And yes, there's a lot of laws that govern it. Is there something specific?
No, not really. I didn't have anything specific. I was just wondering whether that's different than, you know, the individual.
Yeah. So there are interesting things about copyrights if there's more than one owner. And think of it, I just kind of use this example. So think of the house that you own, and you may own it with a spouse or something, right? And the way that you own it, you can't sell your piece of it without your, you know, how you're co-owning it with your spouse, with them being in agreement, right? But copyrights owners can sell their piece of ownership without, I'm sorry, patent owners can do that. But, you know, copyright owners may have to get permission from a joint copyright owner to sell their piece, right? So it's different from patents where you can actually do that. So there are nuances to jointly owned things. Patents are different, copyrights are different. But if you think about how you might own a house, and there may be different ways of owning it, but typically if you're owning it, with a spouse, you cannot share, you can't sell your half interest in it without having your spouse actually say, yeah, I'm a joint owner, you cannot sell it. Copyrights and trademarks are one of them similar and one of them is a little different. So yes, there are laws that are around if there's two owners. And so again, that's kind of getting into the weeds of things. If you had a specific question, we could talk to you later offline about it. But yeah, there's a lot of things we haven't shared, talked about. Do we even want to get into the weeds on it here?
Thank you so much. You guys were so animated, and I loved it was just so interesting. And thanks. I wish there were more people here to, hear what UMBC has to offer. But we who are here really, benefited from what you shared, Krishna and Wendy. Thank you so much. And
the slides be shared. I'm sorry.
yes, go ahead.
Yeah. Wendy, can you share the slides?
Yeah. I think Krishna's going to email them to
Amy.
I've forgotten.
Amy Barnes, who organized everything. Yeah.
Wonderful. Thank you. Thank you so much.
I'll be happy to share them out with everyone along with the recording.
Thank you.
Thank you all. We're at time, so we'll say goodbye, and thanks everyone for being present.
Thank you.
Thank you. Bye.